What we're going to talk about today is a common question that I get asked, and I call it the finder's fee question that I get from clients often. Um, I'm raising some money and I've got some guys, they know some people, and they'll help me bring in some of the money for my company, my project. And I want to just give them 10% of the amount of money that they raised. So I want to go over just a little bit of the law behind this and why it is a potential problem. So let's share my screen here. All right, so finders, when someone brings in investors. So the question usually is, okay, I have someone who can help me bring investors in to complete a deal. A lot of times it's in a real estate transaction. Hey, we need some money for the equity side of this deal. And John Smith, he's got a bunch of people he knows. He'll bring in $10 million, but he wants 10% in cash in exchange for bringing those people in. Can I pay him based on the amount of money that they raised? So the legal issues surrounding this mostly involve the Securities Exchange Act of 1934, which is a federal law dealing with securities. Section 3A and 15A deal with whether you're a unregistered broker-dealer, and I'm going to explain what that means. And also Section 29 when it discusses a rescission right. So what is a rescission right? Section 29 of the Securities Exchange Act. There's also state laws on this. Essentially, it's a right of someone to get out of a contract, to rescind or void the contract. So somebody signs an agreement to invest in your company, they give you the money, 6 months down the road, they find out there's some kind of problem and they want to void the contract, get their money back, plus the legal rate of interest. And there's both federal and state law on this, that they can get their money back if there is a rescission right that's triggered. And that's usually triggered by if something was not done legally in the transaction. This right can last under federal law a minimum of 3 years, sometimes longer, a year after it's discovered. So potentially 3, 4, 5, 6 years down the road, you could be looking at a potential rescission right. Now, this is a problem, especially in deals where, okay, you've got, for example, real estate. You put the cash into real estate, there's a hold period. All of a sudden, 6 months in, you find out, oh, well, there's a rescission right because we didn't do something right. And now all my investors have a right to get their cash back, but I don't have their cash. So how am I going to come up with their cash? And this could basically affect both the person bringing the investor in, the finder, or the company itself could be subject to a rescission right, and as well as SEC enforcement, regulatory action. But so the company also, the finder agreement, let's say that they had a written agreement with somebody that said, hey, I'm going to get 10% of the amount of money I bring in, and they haven't paid the full amount yet. And then it turns out there's a rescission right because they're an unregistered broker-dealer. Suddenly, the company no longer has to make that payment, and the finder is out of luck because you cannot enforce an obligation that's not legal. So why is it not legal? So if you're acting as an unregistered broker-dealer, it's covered by Section 15 and Section 3 of the Securities Exchange Act. A broker-dealer is basically someone engaged in the business of effecting transactions in securities for the account of others. What that basically means is offering or selling a security, in other words, an investment. Most of the time, a security, stock, promissory notes, membership interest in an LLC, bonds, investment contracts, just about anything, even crypto. That's an argument of whether that's a security. Buying, offering, or selling that to an investor is acting as a broker-dealer. The finder could be sanctioned by the SEC if they're not licensed or registered basically as a broker-dealer, which you have to go through a process with the SEC to become a registered broker-dealer, subject to all kinds of regulatory issues. So most people are not registered as broker-dealers. Therefore, if you're acting as a finder, you could be fined, sanctioned by the SEC. They could come after you and say you could no longer ever be involved in raising capital for anyone. It can have a huge impact. And they can also do that to the company. So if you're the sponsor of a deal you put the deal together, and it turns out you hired an unregistered broker dealer, and the SEC finds out, they could sanction you and basically say you can no longer raise money, period, ever. That is the potential that can happen to you, both on a state or a federal level. Some of the factors that are looked at. So obviously the first thing is, are they registered? If they're registered as a broker dealer, they probably can get compensation for bringing in investors and capital. Basically, either a success fee, if they raise a certain amount of capital, a set fee, or a percentage of the amount of money they raise. If they are not registered, the SEC goes through a couple different factors to look at, are they acting as an unregistered broker dealer? Most of the time, if you're basically bringing people in as investors to put money into a deal, it's probably acting as a broker. The biggest factors to say, is it something that we're going to pursue as the SEC? Is it transaction-based compensation? So if you have an agreement with a finder, I will give you 5% of the amount of money you've raised. Boom, transaction-based compensation. Almost always the SEC is going to say that is not okay. If the finder is soliciting investors, so if you're just giving an introduction, hey, company XYZ, here's a list of some people I know that are investors, feel free to contact them, and just making an introduction. However, when you're going out and looking actively as a finder for an investor, and you say, hey, I've gathered this network of people, I'm willing to offer my network to you in exchange for a percentage, probably not okay. Also, if the finder is providing any kind of advice or negotiation on behalf of the company, like, hey, we'll give you a better deal on the stock, we'll give you a better price, or telling people, hey, this is a great investment idea, you're probably also acting as an unregistered broker dealer. If you have a prior history of any kind of sales of securities, or if the SEC has come after you before for this, that's going to be a problem too, something that they look at. There are limited finder exceptions in both the state of Texas, state of California. There's a whole process I won't get into of potentially having to register as a finder, and it only is very limited circumstance that it would apply. Now, there is a proposed rule that the SEC has looked at, but it's been sitting there for years, so it probably will not go into effect. But that rule basically says, if you just provide basically an introduction, you're not giving advice, you're not negotiating, and you're basically just introducing someone to an investment opportunity. And depending on the exception, sometimes you can get transaction-based compensation, sometimes not, just maybe a set fee, hourly rate, whatever it is. But again, Texas and California have a limited version of that. And the rule with the SEC is only proposed. So there is really no finder's exception, which some people think that there is, and there is not. So bottom line, what can you do? Obviously, find somebody who's registered as a broker dealer, which is not always that easy. Most people who do this make introductions and they're not registered. Also, avoiding the key factors, transaction-based compensation. So it's pretty common where in deals I'll see, people say, okay, well, I'm going to give you a certain percentage of the profit split in the future. It's not really, it's kind of based on how much money you brought in, but it's not really transaction-based compensation. That's never really been ruled on. Is it probably a violation? Probably, but there's no set guidance on that. And also obviously avoiding any of the other key factors, telling them they cannot negotiate or provide advice, only just make an introduction, finding out some other way to structure them to get paid. But also understanding the risk that if it turns out that either the SEC, state regulators, investors who sue for a rescission right, that can come back to bite both the finder and the company, because there's things like prohibited from ever selling securities or raising money in the future, giving back all of their money, even if you don't have it, basically coming up with their cash to give the investors back for a right of rescission, plus a legal rate of interest, monetary sanctions, fines. Generally, there's not really any criminal unless there's some type of fraud involved. But if you're using an unlicensed or unregistered finder, guess what? They're probably making some statements on your behalf that may not be completely accurate, and you can be held responsible for those as material misstatements, which is fraud, securities fraud. So be very careful in who you deal with and understand the risks. And thanks for watching. Make sure to subscribe.